Good morning, everyone, and welcome to our last Employment Club session of 2021. Our Employment Clubs are currently an online quarterly event. This session is intended to be an hour long. We will have a questions and answers session after each talk. And thank you to those who have submitted questions in advance. We will try to pick those up either during the talks or the Q&A session itself. Just by way of a bit of housekeeping, we will be recording the session and we'll distribute a copy of the presentation after the event, and we won't share any attendee information as part of that. You should all see a Q&A feature at the top right hand side of your panel. To expand that, simply click the right hand arrow and submit your questions to our speakers. Questions can be submitted throughout the webinar and we will anonymize them when we respond. And if you can't see the panel, click the options button in the bottom right hand corner, which has 3 white dots, and Q&A will then be an option at the top, and you should be able to click that once to re-enable it. We will also run some polls throughout the session where we will be looking to get an indication of, I guess, sort of how some of you are looking at some of the areas we're talking about within your businesses. Those will also be visible in the right-hand panel, and once a poll is launched, we'll let you know and we'll give you 30 seconds to respond. We'll then share the results and anonymize them. Now, to get started and just to make sure everyone's practiced on the polls, we're going to do a warm-up poll. It's not a serious legal one. It's just a chance for you to see how the polls work. You should be able to see the questions coming up on your screen now, and we're asking you when it is acceptable for shops to start playing Christmas music. So is it at any time of year, because you can never have enough of Mariah Carey and Michael Bublé? Is it from the 1st of October, 1st of December onwards, or never bar humbug? So I will pause there for you all to give us your insights on this.
Uniform almost.
Looks like
changing.
Yeah, still going, I think. I think most people have probably voted, and it appears like you all think that Advent is a good time for the shops to start, but no earlier. Personally, I am very much with never bar humbug, but that's probably just me. So just to introduce ourselves before we get on with the talk. I am Dan Fawcett. I am a legal director in the Southampton employment team at Womper Bond Dickinson, and I'll be ably assisted by Chloe Grant, who is a solicitor in our Bristol team. So without further ado, I will get on to the first part of today's talk. That's essentially doing a sort of employment law wrap up of the year, where we look at a number of interesting case law decisions that we've had over the past 12 months or so. As most of you will know, employment law is an area that's forever evolving through the courts and the tribunals and how they interpret the legislation we have, and therefore there's always plenty going on for us to update you on at the end of a year. So to start, we're going to pick up 3 discrimination related cases. The first of these, Elaine Galen, deals with the importance of equality and diversity training. Now, there are 2 very important reasons for conducting equality and diversity training in your organisations. The first one of those is that it is very much the right thing to be doing. Anything you can do to be raising awareness of equality and diversity issues amongst your staff and make your organisation somewhere where everybody feels able to be themselves and people with protected characteristics feel protected and like they have as much opportunity to succeed as everybody else is clearly a good thing to be doing. However, there's a second reason why equality and diversity training is important, which is that if you face a discrimination claim, it potentially gives you a defence to the claim, even if some discrimination has occurred, if you can show that you have taken all reasonable steps to prevent such acts of discrimination. And that will generally mean having an updated equal opportunities policy, making sure employees are aware of it, and, as I've said, carrying out equality and diversity training. Now, the case of Elaine Galen is an Employment Appeal Tribunal decision which really looks at how good and how regular that training needs to be for an employer to actually succeed in relying on that defence. So in this case, Mr. Galen described himself as being of Indian origin, and he joined the business as a senior data analyst and was dismissed 11 months later for performance-related reasons. He complained that he'd been subjected to harassment by a colleague, Mr. Pearson, on the grounds of his race, and that had occurred throughout his employment. An investigation took place, and it found that Mr. Pearson had made racist comments. He admitted it and claimed that they were racist banter being the word that no employment lawyer ever wants to hear when defending one of these types of claims. And he was ordered to undertake further equality and diversity training. But Mr. Galen then brought claims against his employer, including for harassment, and they tried to rely on the reasonable steps defence. The training in question had dealt with race harassment, and it had been delivered about 18 months before Mr. Galen had joined the company, and that was about 2 years before the harassment that had occurred. Tribunal rejected the employer's defence, and they awarded Mr. Galen £5,000 by way of compensation for injury to feelings, and LA then appealed to the Employment Appeal Tribunal. They again dismissed the appeal. The issue here was that the training that LA had carried out was effectively so stale that they couldn't show they had taken all reasonable steps. In order to be able to succeed on the defence, they would have to have carried out refresher training. And when considering whether someone can rely on the reasonable steps defence, the EAT said that the tribunals have to look at both the nature of the training, its quality, and the extent to which it was likely to be effective. In this case, it had clearly not been effective because Mr. Pearson had made the racist comments. A colleague who had heard him had not reported it, and 2 managers who'd been informed of the racist remarks had done nothing. And therefore, not only had it failed to prevent the perpetrator from carrying out harassment of Mr. Galen, but it had also meant that there clearly wasn't a management culture of taking steps to resolve complaints when they occurred. So what does that mean? It means for employers you certainly cannot just be carrying out training for new joiners or doing it every few years and assuming that that's enough if you want to be able to rely on the defence. I think we would always have taken the view that in the vast majority of cases where some discrimination has occurred, it will be very difficult to rely on the reasonable steps defence, but that doesn't mean that it will always be impossible. But I think what you do need is for it to really be part of the culture of your organisation. So you will certainly be in a much better position to rely on that defence if you are perhaps carrying out training on an annual basis. There are regular communications on equality and diversity issues. You have sort of support networks in place, and you effectively live your policies as well as just having them. I think it's also really important that there are genuinely steps taken to act upon complaints of discrimination when they occur, and the employer here may perhaps have been in a different position, even in circumstances where the discrimination occurred, if the managers had immediately taken steps to deal with it when they were aware of it and could point to other occasions where they'd done similar things. Now, I think one of the challenges that employers may face at the moment when it comes to equality and diversity training is how to make it effective in a remote environment where not all of your employees are in the office, because if you're doing it via e-learning, it will be very easy for someone to put the training on in the background, listen to the video or whatever it is, but really be getting on with their other work, and that is not going to be effective. So I think trying to make sure that if you're doing training in that way, it's interactive and employees are properly engaged in it, will make it more effective. I think one other point that's worth bearing in mind, if you do ever want to be able to rely on this defence, is not only keeping records of who has done the training, but actually what content was delivered. I think quite often when I've spoken to employers and we've had to say, well, does anyone have a copy of the training that was carried out 3 years ago? Quite often the answer is no. And you're clearly going to be in the back foot in that scenario. So the next case we're going to pick up is that of Forstater and CGD Europe. And this deals with a particular incident of a philosophical belief discrimination claim. Now, in many ways, philosophical belief claims are quite rare. I think in my career, I've dealt with a couple of religious discrimination claims, but I've never actually had to deal with a philosophical belief claim. That's probably in part because a lot of employees are probably not aware that something they believe could potentially be a philosophical belief that's protected in law. But I think they can also be quite difficult for employers to deal with, because you may not be aware that an employee's opinions are at such a level that they consider them to be a protected philosophical belief. And it's also an area like religious discrimination where it's very easy for someone's beliefs to come into conflict with other protected groups, and can therefore be difficult to manage in the workplace. And the Forstater case is an example of that. So essentially, any belief can be protected as a philosophical belief under the Equality Act if it has a certain degree of seriousness and cogency, and it is, the term that's used is, worthy of respect in a democratic society. Now, in Ms. Forstater's case, she was a visiting fellow at a not-for-profit think tank, and she believes that a person's sex is a material reality that should not be confused with their gender or gender identity. Essentially, she believes that being female is an immutable biological fact, and a trans woman is not in reality a woman. She didn't have an issue with people identifying as another sex, or with the fact that people can change their sex by law. It was just that she has this underlying belief in it being an immutable fact. She engaged in debates on social media about gender identity issues, and during the course of those, she made remarks that her colleagues found offensive. Following an investigation, her post was not renewed, and she brought a claim alleging that her belief in there being only two biological sexes was a protected philosophical belief, and that she'd therefore been discriminated against when her contract was not renewed. Case went up to the Employment Appeal Tribunal, and they essentially held that her gender critical beliefs could be a protected philosophical belief under the Equality Act. Essentially, their view was that a philosophical belief will only be excluded from protection if its expression would be akin to Nazism or totalitarianism, or might incite violence or hatred. So, in essence, unless a belief was really extreme, then it is potentially protected in law. In the case of Ms. Forstatter, she was not seeking to destroy the rights of trans persons, and therefore her beliefs did not fall into that sort of extreme category. And the EAT was clear that a belief that is offensive, shocking, or disturbing to others can still be protected. Now, that's not the end of the case. It has gone back to the tribunal, who will need to decide whether, in fact, Ms. Forstatter's contract was not renewed because of her beliefs. But what this case certainly does do is it establishes that a gender-critical belief can be protected in law, and more widely, it makes clear that all but the most extreme beliefs are capable of being protected by the Equality Act. Now, in a way, I think that's quite helpful for employers, because it may well mean that in many philosophical belief cases, you might not spend a lot of time worrying about challenging whether a belief can be protected, because you've got a clear steer from the EAT that unless it's extreme, it might be. Now, what I don't necessarily think is the case is that this would mean that someone with a belief similar to Mrs. Forstatter's would almost be able to upset others without impunity just because they have a protected belief. There are a number of cases involving religious beliefs where the tribunals have accepted there is a difference between someone's belief being protected and action that is taken due to a manifestation of that belief. And for example, there have been cases where in certain circumstances, people who've been dismissed for proselytizing or wearing religious symbols have been held not to have been discriminated against, because it's not the belief that's the reason for the treatment, it's the manifestation of it. And I think what that probably means in practice is that if you have got someone who, because of a particular belief, is upsetting employees from other protected groups, if you engage with both sides, you try to mediate, you try to encourage them as to how to express their beliefs without causing upset, and they don't get the message and they continue to cause conflict, you may well still be able to take action in that situation. It's just that you need to be very alive to the fact that it is potentially a protected belief, and to have probably been through that engagement process first. The final discrimination case we wanted to pick up is a case of Rooney and Leicester City Council. And this deals with the question of whether the menopause can be held to be a disability under UK employment law. Now, over the last 12 months or so, there has been quite a bit of publicity around the impacts of the menopause on women in the workplace. And there is a statistic that apparently over 50% of female employees are menopausal or postmenopausal women, so it potentially affects a large proportion. And a number of women have apparently considered leaving the workforce because of difficulties that experiences they have from the menopause cause them in their day-to-day work. So it's becoming a sort of a hot topic in employment law. Now, there are probably 3 different ways that someone might want to present a claim that they've been discriminated against through, say, how they've been managed as a result of symptoms of the menopause. One might be an age discrimination claim. That may be relatively difficult to get off the ground on the basis that some women will experience the menopause early, and there will be sort of differentiation between age groups of when they experience it. Another might be a sex discrimination claim, but again, that may be relatively difficult because clearly not all women are menopausal or postmenopausal. It may well be that an indirect sex discrimination claim may be an option, but direct sex discrimination may be more difficult. I think what that probably means is that claims are most likely to be effective if presented as a disability discrimination claim, provided that menopausal symptoms can be seen as a disability, and that was addressed by this Rooney case. So she was a child care social worker until she resigned. And she had had a number of symptoms as a result of the menopause, which included insomnia, fatigue, lightheadedness, confusion, stress, depression, anxiety, palpitations, memory loss, joint pain, migraines, and hot flushes. And clearly, that combination of symptoms had left her physically and mentally unable to cope for a number of years. She'd had to spend long periods of time in bed. She'd received hormone replacement therapy and was under the care of a specialist menopause clinic. Now, at tribunal level, the Employment Tribunal nevertheless did not accept that she met the definition of a disability under the Equality Act, and she then appealed. Now, by way of a reminder, the definition of a disability under the Equality Act is a physical or mental impairment that has a substantial and long-term negative effect on someone's ability to carry out normal day-to-day activities. And to be long-term, it has to last or be expected to last at least 12 months. Now, from that list of symptoms I've just read out, sounds very much to me like there was a substantial adverse effect on Mrs. Rooney's ability to carry out day-to-day activities, and perhaps unsurprisingly, the Employment Appeal Tribunal agreed with that, and she was successful at appeal level in establishing that the way that she personally was affected by the menopause was enough for it to amount to a disability. Now, that does not mean that every single menopausal woman in the workforce will be held to have a disability. Clearly, the way people are affected will vary greatly from person to person, but it certainly does mean that it is potentially a disability, and therefore that if you have managers who do not make allowances for women who are going through the menopause, perhaps sort of see them as taking too much time off and not really contributing to the team, well, there is a real risk of successful disability discrimination claims in that situation. So employers may want to be thinking about introducing a menopause policy, training for managers, and might also just want to also bear in mind that the menopause can also be experienced by non-binary employees who are biologically female or trans men, and therefore it's often a good idea not to make assumptions as to who may or may not be being affected by it. So our poll for you here is to ask whether in your organizations you have a menopause policy, whether you're looking at introducing one, you're not, or you don't actually know. So I will pause for 30 seconds whilst we open up the poll up for you to fill in your answers. So it looks like we've got a good range of replies there. 22% of you have got a menopause policy. I'm quite impressed. I thought that we may well have a lower answer for that. 29% of you are considering introducing one. 27% don't have one, and looks like you're not currently, and 8% if you don't know. Now, I think there's always a danger in employment law and HR that you can become too focused on having a policy. So for those of you who don't currently have one and aren't thinking about it, that it's not necessarily a bad thing, as long as it's an issue you are alive to in your organizations. And for those of you who do have a policy or are considering one, I think the key point is that getting this right will involve much more than just having a policy on your intranet. Far too often in HR, businesses will have policies, but they may not live them on a day-to-day basis. I think a particularly good example is probably stress at work policies. Lots of companies who have got a stress at work policy are nevertheless not great at managing mental health in the workplace in practice. So as important as having a policy is awareness raising and management training. And I think certainly if you're doing those two things, then hopefully you will be improving the lot of menopausal women in your workplaces and ensuring that your managers are making allowances appropriately. So moving on from discrimination, I will now pick up a couple of recent unfair dismissal cases. The first one of these, LVK, deals with a dismissal of a teacher who had been suspected of possessing indecent images of children, but who had not been charged. Now, I've had to deal with a few disciplinary cases in my career involving employees suspected of possessing indecent images of children, and they are always very difficult cases for the employers to manage. Clearly, it's an emotive issue. And one of the problems with that is that very often thinking about it in a sort of clear and rational way can sort of fall to one side. And that will actually then mean that the employer might not be in the greatest of positions to defend an unfair dismissal claim if they get one. And this case, I think, illustrates why taking a very clear and rational approach is really important. There are 5 potentially fair reasons for dismissal. You'll be familiar with most of those. So conduct, capability, redundancy, breach of a statutory restriction, or there's a catch-all category of some other substantial reason. Now, this case is one where effectively the employer used that some other substantial reason approach well. So the teacher had been charged with possessing indecent images of children, but the charges were dropped and he was not prosecuted. His son lived with him and also had access to the computer, so could have downloaded the images. The son was also charged, also not prosecuted. The teacher had 20 years unblemished service. He told his employer about what was happening, and he was called to a disciplinary hearing. The employer decided that there wasn't enough evidence to conclude that he had downloaded the images himself, but there was a risk that he was responsible, and given his role, that posed an unacceptable risk to children. There was also a potential reputational risk to them, and they therefore dismissed him, and he claimed unfair dismissal, essentially on the basis that actually, he was not charged. There was no way of proving that it was him that downloaded the images. Went up to the Court of Session in Scotland, which is their equivalent of the Court of Appeal, and the reason that had been used for dismissal had been some other substantial reason, and that had meant that the employer in this case did not need to have a reasonable belief that the claimant had downloaded the images. They'd concluded that they could not maintain trust and confidence in him to protect children and couldn't take any risks, and they'd acted reasonably in treating that as a sufficient, some other substantial reason for his dismissal. So I think that this is a really helpful case in showing that when you're dealing with cases involving potential criminal charges against employees, whether they proceed or not, getting your allegation wording right and being really, really clear on why it is you've decided to dismiss is really important, because if you get it right, you should be in a good position to defend an unfair dismissal claim. Clearly, the role of an employee will be important, and the extent to which the offence they have committed is relevant to that role. But it's certainly the case that if you can build a good case as to why even someone having been charged with the offence has an impact on their role, then that may well put you in a much better position to defend an unfair dismissal claim than effectively going after the underlying offence as a misconduct reason. The other unfair dismissal related case we wanted to pick up is Gwyneth Council and Barrett and another, which deals with something that's been a grey area for quite a long period of time, which is whether or not it is mandatory to offer an appeal as part of a redundancy process. So Mrs. Barrett was a PE teacher at a secondary school. School was being closed permanently and replaced with a new joint primary and secondary school. And she unsuccessfully applied for a role at a new school and was made redundant, and then claimed unfair dismissal on various grounds, including that she hadn't been given a right of appeal. The council argued an appeal would have made no difference here because the school was going to close. Now, the case went all the way up to the Court of Appeal, and they held that the absence of an appeal in a redundancy case does not of itself make the dismissal unfair. So it would be wrong to find that someone's redundancy dismissal was unfair simply because they had not been offered an appeal hearing. Now, it is one of the many factors that do need to be considered in determining fairness, and in this case, they nevertheless decided that not offering the appeal was outside the band of reasonable responses, and therefore that Mrs. Barrett was unfairly dismissed. But I've certainly had to advise on a number of occasions as to whether or not there is a legal right to appeal a redundancy dismissal, and getting confirmation that there is not is clearly helpful guidance. I think it's very much one where it will depend on the facts. I think if a site is being closed and there are no possible opportunities for an employee anywhere nearby in terms of alternative employment, well, maybe you may get away with not offering an appeal there. I think one of the issues the council would have had in this case was that there were other roles that Mrs. Barrett could have applied for. An appeal could clearly be relevant to that process. And I think certainly in any kind of selection type redundancy, it will still be much safer to offer an appeal, but nevertheless helpful to get guidance that it's not an absolute right, and failing to offer one will not necessarily render a dismissal unfair. So those were the unfair dismissal cases we wanted to pick up. We now have a TUPE case for everyone's enjoyment. So most of you will hopefully be aware that TUPE, or when not abbreviated, the Transfer of Undertakings Protection of Employment Regulations 2006, apply in circumstances where either a business is being sold or you have a insourcing or outsourcing type scenario, usually referred to as a service provision change. Now, the sort of service provision change type scenarios are usually fairly straightforward if the work is all going to one place. So you've got one employer that, I don't know, has a cleaning service and they decide they want a new supplier to do cleaning for them. So they terminate the old supplier's contract, engage a new cleaning services provider, and in effect, the employees will simply transfer across to that new provider, who would usually refer to as the transferee. It can become much more complicated if a contract is being split up. So if you take that scenario and there are 3 different sites or several different shifts, and for whatever reason, different contracts have been awarded to several different suppliers, there is a question mark as to whether employees can transfer, particularly if the work they do is going to be split up among several different providers. There was a case in the in the European Court of Justice called ISS Facilities and Covet, which held that in a business transfer scenario under the European directive from which TUPE is provided, you could split someone's employment contract between transferees in circumstances where the business was being transferred to more than one person. That was provided that that was possible practically, and it didn't adversely affect the workers' rights and working conditions. Now, that in effect potentially means that a business could be split up and an employee could end up with 2 or maybe even 3 part-time contracts because the work they do has gone to different organisations. The McTeer contracts case deals with whether that can apply in an outsourcing type scenario. The reason why that was unclear is because service provision changes are sort of a UK invention under our version of TUPE. They're not actually derived from the European law, and therefore, in principle, our courts and tribunals didn't have to follow the ECJ's approach in the Covet case. In this particular case, Amy Services Limited had a contract with a council to replace kitchens in social housing. There were 2 teams who worked independently, and the council retendered the contract, and it was split into 2 geographical areas. Amy gave redundancy notices to its employees originally, and it then withdrew them when it actually decided that potentially TUPE applied here and the employees could be split up between the 2 new contractors who had been successful in the retender. And it therefore allocated its employees between those 2 businesses and said that they transferred in 2 separate groups. Those companies refused to take on any of the employees, and they issued tribunal claims. Now, the ECJ, sorry, not the ECJ, the EAT in this case held that it didn't have to apply the ECJ's Covet case to service provision changes, but it would be undesirable to take a different approach to those to business transfers, and therefore it would do so. So what that essentially means is that following a service provision change, someone could potentially have 2 or more contracts with different employers, provided that it works to split up their work in that way. And the case has been remitted back to the tribunal for it to consider the application of the ECJ decision to the facts of each claimant in this case. So I think what that essentially means is if you are a client doing a retendering exercise, or you are someone's outsourced provider, you can't simply assume that if the contract is going to be split between 2 different businesses in future, there will be no TUPE transfer. It will be necessary to examine the circumstances very carefully and probably to take advice if necessary. Now, we've then got one case on collective bargaining, which I will try and pick up fairly quickly because this will, broadly speaking, only be relevant to those of you who have a unionised workforce. Essentially, if you have a collective bargaining employment with a union, you are prohibited from making direct offers to employees of new contractual terms if those are that your main purpose in doing so is to achieve what's known as a prohibitive result. And a prohibitive result is that the workers' terms of employment will no longer be decided by a collective agreement negotiated by the union. So essentially, you're not meant to try and get around a agreement with a union by making offers directly to the employees. Costal, in this Costal and Dunkley case, was in negotiations with its union, which had stalled. And it told employees that if they didn't accept an offer that was being made to them of new terms, they would not receive a pay rise or a Christmas bonus. They were later warned that if they did not accept, they would be given notice, and 57 of them brought a claim alleging that this was effectively an offer intended to achieve a prohibitive result. The Supreme Court agreed. Essentially, employers can make an offer directly to employees once all collective bargaining has been exhausted, but this employer had been effectively too early and premature in doing that, and therefore there was a real possibility that the effect of their offer was that the employee's terms would have been determined otherwise than by a new collective agreement with the union. In practice, this means that if you have a collective agreement, then you can only make offers directly to employees once you have reached the end of all dispute resolution processes under that agreement. That the challenge can be that very often collective agreements are quite woolly, and it may therefore be quite difficult to decide when you've reached that point. So we have one final case which I'm going to cover, and then I'll just have a quick look at the Q&As before handing over to Chloe to deal with what's coming up in employment law section. And this case is one of Kong and Gulf International Bank, which deals with whistleblowing. So to cover this one briefly, there was a Supreme Court case in 2019 of Royal Mail Group and Duty, which decided that if a person in a hierarchy of responsibility within an employer decides an employee should be dismissed because of an act of whistleblowing, but invents an alternative reason that is then adopted by the decision maker, so the dismissing manager, the real reason for the dismissal will not be that invented reason, but it will be the act of whistleblowing. So since that case, that I've come across a number of examples where even though a dismissing manager had no idea about an employee's whistleblowing, the employees sought to rely on the duty case to say, well, there must be an invented reason in here and it must all be about the whistleblowing. The Kong case is, I think, helpful in narrowing the application of duty, or at least being clear that it should have narrow application. This was a case where Ms. Kong had some concerns about some legal agreements within the bank that she worked for, and she reported those to the head of legal in a way that made the head of legal feel that her professional integrity had been criticised and undermined, and she then mentioned it to the head of HR and CEO, and Ms. Kong was eventually dismissed for the way in which she had criticised the head of legal. So she sought to argue that she'd been dismissed for being a whistleblower, and the claim was rejected up at Employment Appeal Tribunal level. Generally, the only motivation that should be attributed to an employer is that of the decision maker. And in this case, the decision maker had not been misled. The head of legal had not invented the reason why she was upset. It was genuine. And therefore, the dismissal was not because of the whistleblowing. Now, it will often be difficult to separate an act of whistleblowing from the way someone has blown the whistle. But this case is clear that if someone behaves unreasonably in the way they raise some whistleblowing, then it may well still be possible for them to be fairly dismissed rather than automatically dismissed for a whistleblowing related reason. Don't think I can see. Oh, hang on. I've just trying to see if I can see any of the Q&As that have come through. I've had a question about the idea that it will be difficult for a menopausal woman to claim under sex discrimination. The reason why I think that will face some challenges is because in order to show that someone's been treated in a particular way because of their sex, it needs to be the sex itself that's the reason for the treatment. Additionally, not all women are menopausal, and that will probably make it difficult to rely on sex discrimination. It would have to be based on an indirect sex discrimination claim that women are more likely to be adversely affected by an employer's policy because of the menopausal symptoms that a substantial proportion of them will suffer from at a stage in their life. So it's not as clear cut as I am, in fact, it is not I am female and therefore I have menopausal symptoms, and therefore it's not intrinsically part of sex discrimination, and therefore doesn't easily lend itself to a direct claim, albeit indirect might be an option. This stage, I will hand over to Chloe to take you through what's coming up in the pipeline session.
Fantastic, thank you, Dan. If we can just jump on a slide, please, Crystal, that would be great. So yes, hello, I'm really pleased to be here talking to you this morning. Dan's looked at what's happened already and how it might affect you. I'm here to discuss upcoming developments and issues, changes that are on the horizon that you need to know about. I'm conscious of time, so I will rattle through or do my best to rattle through. And if we have time, I'll deal with questions at the end, much like Dan. And please do submit them via the Q&A function. Okay, you can see a timeline 2021 to 2023. I will start with the first point on that timeline, care homes. Now, if you've watched the news recently, you may well have seen that as of the 11th of November, anyone who works inside a Care Quality Commission registered care home in England must be fully vaccinated against coronavirus unless they are exempt. Now, the person responsible for checking this is known as the register person, and they've got to ensure that no non-resident adults can enter unless they've provided evidence of either full vaccination or that they can't be vaccinated clinically. There are some exceptions to this, so residents' friends and relatives, for example, and or those who need to enter to provide emergency assistance. We've got some guidance from the Department for Health and Social Care to assist the implementation. And that says employers should keep records of vaccination or exemption status. It recommends vaccination policies are a really good idea, although I do hark back to Dan's earlier comment about policies need to be backed up with action and with training. And it also suggests employers may need to consider deployment to an alternative role within the care home structure if someone hasn't had a jab, or their 2 jabs, I should say. If that won't work, the guidance says the employer may have, depending on the circumstances, a fair reason for dismissal. Now, staff can self-certify at present, but from the 25th of December, care home workers who are medically exempt will need to verify their status using the NHS COVID pass, having completed an exemption application. So big changes, lots to be aware of. If you need help on that front, please just get in touch. Okay, I'll talk about flexible working next. Now, you may be aware that on the 23rd of September this year, the UK government published a consultation setting out proposals in order to support its own manifesto promise made back in 2019 of making flexible working the default position. That is going to close on December of this year. It was set up to consider various things, including, making the right to request flexible working a day one right, whether the 8 business reasons for refusing a request remain valid, and whether employers should have to suggest alternatives if they intend to refuse a request. Following development in home and hybrid working, employees are really, starting to value the opportunity to work flexibly, and these are big changes. Dan and I are both speaking to you from home today, which is something that probably wouldn't have happened 2 years ago, almost certainly wouldn't have happened really. All of these developments, coupled with the consultation results, may well lead to an increase in formal statutory flexible working requests. Now, we were going to do a poll at this point, but I think with an eye on time, we won't. But basically, we were just sort of looking at how changes are affecting you and your business. Even if you aren't seeing those requests coming in yet, it's probably a good time to be looking again at your flexible working policies, thinking about factoring flexibility in earlier in the recruitment process, in role design, all that kind of thing. Okay, and moving on to the EU settlement scheme. As you may be aware, EEA citizens living in the UK post-Brexit had until the 30th of June this year to apply for settled or pre-settled status. Until the 1st of December, those who missed the deadline to apply under that scheme can still submit a late application where they had reasonable grounds for doing so. In such circumstances, employers are advised not to immediately jump to dismissal and to advise the employee to make an application within 28 days. They then need to make sure that there's evidence the application has been made within the required time, and also that you've got a positive verification notice from the employer checking service. But the big headline there is that these temporary measures will end on the 1st of December. So make sure that date is in your diary. And our business immigration lawyers can help if you've got any queries on the settlement scheme and how you move forward from these developments. So looking at 2022 and developments next year, we've already talked about care home workers, but from the 1st of April 2022, all frontline NHS staff, other than exempt people, must be fully vaccinated against COVID-19 to continue in their posts, subject to parliamentary approval of the regulations that are proposed. This is a really, really wide-ranging change. It will cover doctors, nurses, dentists, as well as staff like porters or receptionists who may have face-to-face contact with patients, even though they're not directly involved in their care. We know that guidance is being produced and there will be a grace period of, I believe, 12 weeks between the regulations being made and implemented. And that's intended to allow workers to get vaccinated and to allow NHS sites to get used to what's coming. I think in terms of numbers, to put it in context, almost 90% of NHS staff are already double dosed. But obviously that outstanding 10% represents a lot of people. So with the numbers in mind, the new approach is being delayed until spring next year to avoid an exodus of staff during the winter months, which is obviously always the busiest time for the health service. And 1st of April is a big day for employment law, as announced in the recent autumn budget. Higher national living wage and national minimum wage rates will also apply from that date. So the increased hourly rates range depending on age, as they always have, from £4.81 per hour for apprentices and 16 to 17-year-olds up to £9.50 an hour for everyone 23 and over. Just in practical terms of how you're going to be affected by this, if you're not already doing so, you need to start thinking now about how to make sure you can afford these changes and how you're going to implement them so that you are compliant with the law. Also in April, but a few days later on the 5th, the current COVID-19 concession on UK right to work checks ends. So while that's still in force, employers can ask new recruits to send them scans or photos of identity documents and then verify these via video call. But from the 6th of April, employers will have to go back to face-to-face and physical document checks. Now, we know that this isn't going to be applied retrospectively, which is something, but given that so many businesses are still a long way off from a total return to office-based working, it's important to start planning now how to deal with these checks, especially if you're going to be dealing with recruiting home-based people. So again, if you've got any queries about right to work changes, our business immigration lawyers will be very happy to help. Then in spring of next year, we've got new visas coming in. So a lot happening on the business immigration front in particular. The government has said it will introduce an elite points-based visa by March 2022 and a new global business mobility visa at some point in the spring. We haven't got a date for that yet. I won't go into detail with an eye on time, but again, one of our business immigration lawyers can help with any queries you've got about visa applications and the changes and how they might affect you. Lastly, in 2022, the government is due to carry out a formal review of the gender pay gap reporting legislation next year, following which some reforms may well be made. Possible changes include the lowering of thresholds for reporting. There may be a legal requirement to publish an action plan to make the changes necessary. You know, if you've identified gaps, an action plan about how you're going to tackle them. And also we may see the extension of reporting to include ethnicity pay gap data also. So it's a case of watch this space for further details. And a new right to statutory neonatal leave. That's the last point on this slide I'm going to cover, looking ahead into 2023. This is going to be applied to when there's a baby that's 28 days old or less and is admitted to a hospital. So we've got a new right to neonatal leave and pay for up to 12 weeks. Don't know when in the year this will be coming in, but this will be a day one right. Parents will need 26 weeks service in order to receive statutory neonatal pay, and it's going to be paid at the same rate as other statutory family leave, which is currently set at 151.97 per week. People can take leave in blocks of 1 or more weeks, and those who qualify will be protected from detriment or discrimination arising from taking or seeking their leave. They'll also have similar rights on their return with most other types of family related leave. If I could have the next slide, please. So those are all the key developments in the pipeline where we've got already set timescales. I apologise that it was a bit of a whistle-stop tour, but hopefully we flagged the key things for you. But we also wanted to highlight some really important forthcoming changes for which we don't have dates yet. Again, I'll move fairly quickly through these due to timing, but if you want more detail on anything, please just let us know after the session. So, firstly, the government is to introduce a new duty on all employers to take reasonable steps to prevent sexual harassment at work. It will also introduce explicit protection from third-party harassment and will consider extending the time limit for discrimination claims from 3 months to 6 months. Other than that, the details are fairly woolly. We don't know how it will be enforced. We don't know whether there will be new types of claim that employees can bring. And we're told that legislation will be introduced when time allows, essentially. But to get ahead, employers should be ensuring that you've got appropriate policies in place, held up and supported by regular training, because obviously it's a good thing to make sure that your employees know how to deal and how not to deal with sexual harassment. And again, definitely a question of watch this space. In the aftermath of Me Too and its revelations, new legislation is also going to be brought in to curb the use of non-disclosure agreement provisions in employment contracts and settlement agreements. It's going to be accompanied by a requirement for independent legal advice for the individuals who are being asked to sign. We know that there will also be new enforcement measures for NDAs that don't comply with the requirements, but we haven't got any further details at this stage. And again, no dates, but one to have on the radar. The government is intending to extend redundancy protection to all pregnant women and new parents. This would last until 6 months after the return to work, and again, will be introduced when parliamentary time allows. That catch-all provision that is applying to a few of these. Also, we're told the government is going to introduce a new right for employees managing long-term caring responsibilities to take up to 1 working week, so 5 working days of carers leave per year, which will be unpaid and which will need no qualifying period of service. We're told it's going to be, it can be applied flexibly, so employees will be able to take that leave flexibly and throughout England, Scotland and Wales. Employees taking that leave will be protected from detriment, and dismissals for reasons connected with it will be automatically unfair. Again, no date for that one. And finally, very briefly, I'll only quickly touch on this. The government has announced it's going to bring forward legislation to require employees not to make any deductions from tips received by their staff, other than those required by tax law, which means that administration charges will be unlawful. We know there's going to be a statutory code of practice on tipping, and a breach of obligations in relation to that will be enforceable in the Employment Tribunal. So good news for staff who rely on tips everywhere. If I could just jump onto the next slide, please. Okay, very, very briefly, I did say I'd take questions at the end. We may have time for 1 or 2. I can see I've got, let's have a quick look. So got a question about NHS staff and the COVID booster, which is a very sensible one. Will staff be required to have the COVID booster from next April? Which is a really great question in light of what we've discussed with the double vaccination question. But at present, the new policy will not apply to the booster. We're just talking about vaccination. However, that is caveated that the government will keep it under review. They may amend the regulations. I suppose it may well depend on levels, etc. But at present, we're only talking about vaccinations and not the booster jab. Interestingly, the consultation paper also sought views on whether flu vaccinations should be compulsory, but that's not being taken forward at the moment. Okay, if we could just jump on to the final slide. Thank you. Yeah, I'm sorry, I won't take any more questions now, but thank you very much to everyone who put them forward, just because I'm conscious that we're hitting the end of our allotted slot. That was a whistle-stop tour of what's on the employment horizon, and that brings us to the end of the webinar. And all that remains really is for me to thank you on behalf of myself and of Dan once again for joining us. We hope you found it helpful, but if you've got any follow-up questions on what's been covered today, or if you need a hand with any other employment law related issue, please feel free to contact either of us or a member of our team. You'll see a short feedback questionnaire when you exit the webinar, and it would help us hugely if you could just take a few seconds, shouldn't have thought it'd be minutes, to complete it. We do read everything. All of your feedback helps us to improve these sessions and make them as good as they can be. So thank you very much. I think that's all from me. Dan, was there anything else you needed to add?
No, that's all from me. I think what we will do is anyone who's asked a question, we'll try and get back to you individually if we can, just to try and clear those up and give you the information you need. So thank you all for attending, and I suspect we'll be doing another one of these at some point in the early part of next year. Thanks all. Bye.